One of the mottos of the European Union is united in diversity. However, we have seen a complete centralization of European penal law, especially when it comes to the European arrest warrant and the European Criminal Records Information System, also known as ECRIS. When I went to law school, I was a big believer in the so called international law and how noble it is, only to realize that it is, in fact, very different to what its initial aim actually was in the beginning. And speaking of centralization, I want to touch on the topic of the European Criminal Records Information System, ECRIS, and the European Arrest Warrant. Imagine you're a woman, let's say a citizen of the UK or citizen of Slovenia, and you do let's say a woman has an abortion in Poland or Malta. In Slovenia, for example, abortion is a constitutional right protected by the Constitution. In Poland, it's a criminal offense, also in Malta. Now, if a woman who is a Slovenian citizen gets convicted of an abortion in Poland, that criminal record will appear in Slovenia because of the European Criminal Records Information System, even though abortion is a constitutional right in Slovenia. So, this is one of the things that is profoundly wrong with the current state of European penal law and the European Union. Also, let's take, for example, simple drug possession. Imagine you go to Poland, or I don't know, you go to one of the Baltic states, let's say Latvia, Lithuania, and you're a kid from, I don't know, Portugal or Spain. You go to some club, you smoke a joint, you take some coke, you get arrested. The police finds out that you're carrying a certain drug. You will get a criminal record in Poland or in one country where simple possession is illegal, only to find out that when you return to your home country, you have a criminal record, despite the fact that in your home country, possession of drugs for personal use is totally 100% legal. So, how can you have international law when you know there are so many differences in legal procedure, in criminal procedure, in criminal material law, and this kind of obsession with unification, this obsession with centralization in Europe, it goes against the founding principles or the founding mottos of the European Union. So over the years, I've become actually very much cynical of European Union law. For example, also with the European arrest warrant. I mean, the thing is, there is no such thing as an international arrest warrant. You only have, let's say in the EU, you have a European arrest warrant and then you have Interpol red notices. The thing is that if you commit any crime in another EU country, you can be extradited to another EU country. So we can still say that is an active arrest warrant, but still there have to be certain requirements such as dual criminality. The jail sentence has to be at least 4 months long, or the prescribed prison sentence in the case of a possible prosecution is at least 4 months. And the thing is that the EAW was created right after 9/11, and it was meant for the most serious of crimes, because before it was just like typical extradition law that relied on extradition treaties, or let's say extradition treaties between countries of the Council of Europe. And after 9/11, the European Union wanted to essentially cater to the needs of the United States. And then, therefore, this was imposed. And I believe it carries a lot of legal wrongdoings in these cases.